State of Iowa versus Dakota Van Patten. The state appears by Lynn County Attorney Maybanks, First Assistant Monica Slaughter. Defendant appears in person, represented by Attorney Troll. In an order entered by the court on September 25th of this year, the court accepted the jury's verdict, finding the defendant guilty of murder in the first degree, kidnapping in the first degree, and conspiracy to commit forcible felony. We're here for the scheduled sentencing. A motion for arrest of judgment and a motion for the trial was filed by the defendant on November 6th, and then that motion was amended on November 14th. Resistance was filed by the state on November 14th. So we'll take that motion up at this time. Would the defense like to be heard?
Thank you, Your Honor. As the court correctly noted, we did file a motion for new trial and a motion in arrest of judgment in this case on behalf of Mr. Van Patten. We will rely on the written arguments contained in that motion, but in a supplement, we'll just argue to this court today that the verdict on all three of these counts was contrary to the way the evidence presented and existing law in the state of Iowa. Specifically, as it relates to count one, we believe the jury verdict was contrary to the weight of the evidence as it relates to the elements of murder in the first degree, specifically that the defendant or person he aided and abetted strangled Melody Hoffman, that he acted with malice aforethought, that he acted willfully, deliberately, premeditatedly, and with specific intent to kill. As we argued during trial, we believe that there was no evidence presented to support that the defendant was, in fact, the person who strangled Melody Hoffman. I think the evidence heavily suggested that was Mr. Gruesome. Mr. Gruesome had the motive, had the opportunity, and intent to do so. As we conceded at the time of trial, the defendant, the state presented sufficient evidence that the defendant was, in fact, present, but short of that, there was nothing else to support the notion that he, in fact, aided and abetted or acted with Mr. Gruesome in the commission of this crime. Additionally, there was a lot of evidence presented regarding Mr. Gruesome's phone, which further supported the theory that Mr. Gruesome alone acted at Lily Hoffman in dragging first Melody Hoffman and then walking himself along the back of the vehicle. We have data from Melody Hoffman's phone, specifically as it relates to her Wi-Fi connection, that has it connected to Dakota Van Patten's Wi-Fi data, and then it disconnects for the duration of what we believe to be the act of killing. So again, Your Honor, we believe that the state's evidence proved that Mr. Gruesome was the one who actually acted, but it did not come to the standard to prove that Mr. Van Patten was the one who was either the principal or the aided and abettor in this case. Lastly, as we argued at trial, the defendant's DNA was discussed at length. However, none of the state's experts were actually able to point to when in time exactly that DNA was deposited on all of these items. So for those reasons, Your Honor, we believe there was insufficient evidence presented at trial to support the elements of the offense of murder in the first degree, and respectfully request this court to overturn this conviction and grant him a new trial. As it relates to count two, and as we indicated in our motion, these two counts are closely related, so we will incorporate the arguments that we made as it relates to count one and make the same request on count two. As it relates to count three, conspiracy to commit a forcible felony, we believe again that the jury's verdict was contrary to the way that the evidence presented, specifically as it relates to the elements that require the defendant individually to agree with McKinley Lisa and or William Pimpton that one or more of them would commit a murder or kidnapping, to solicit another to commit a murder or kidnapping, or to attempt to commit a murder or kidnapping, and to enter into an agreement with the intent to promote or facilitate a murder or kidnapping, and finally to commit an overt act. Your Honor, the evidence presented at trial is void of any text messages or any communication or any indication that there was any sort of agreement between the defendant and either Mr. Ledesma or Logan Kington to commit murder or kidnapping. We did review several pages of text messages, but none of them had any indication that there was an agreement ever reached between either one of these gentlemen with Mr. Van Patten to commit such an overt act. As it relates to the overt act element, again, we will rely and incorporate the arguments made as it relates to count 1 and count 2, and we'll request this court overturn the conviction and grant new trial on count 3 as well. And for all the foregoing reasons, we would ask this court to grant our motion as a judgment as well. Thank you.
Thank you, counsel. The state like to be heard in response.
Yes, Your Honor. As the court is aware, under Iowa Rule of Criminal Procedure 2.24, sub 2, sub B, sub 7, a verdict is contrary to the weight of the evidence under our rules by the Iowa Supreme Court only when a greater amount of credible evidence supports one side of the issue or cause than the other, and that the district court has an opportunity to grant a motion for a new trial only when there is more evidence to support the alternative verdict than the rendered verdict, and should only grant a motion for a new trial in the, quote, extraordinary case in which the evidence preponderates heavily against the verdict rendered. Your Honor, we submit to you this is not one of those extraordinary cases that the Iowa Supreme Court contemplated to preponderate heavily against the verdict in light of what this court heard during the course of this trial. Indeed, the only evidence that the defense pointed to that supported an alternative verdict, which would presumably be not guilty, was the exact same evidence that, when looked at as a whole and with all the reasonable inferences of the evidence, also incriminated him. The evidence, if it was compartmentalized or looked at individually, with all the reasonable inferences, each piece of evidence incriminates him, and the jury could find him guilty of that. But more significantly, as a whole, the evidence points to his guilt when looked at in those regards. Essentially, Your Honor, the defense argument here would be that the state was required to produce some kind of direct evidence in the form of witness testimony or video evidence showing exactly what the defendant did to Melody Hoffman in terms of laying his hands on her to kill her. And that's not what is required in order to prove these crimes against him. First of all, it ignores the fact that there is a substantial and overwhelming amount of circumstantial evidence pointing to his guilt, not only as a direct participant, but also as someone who aided and abetted the reason. I want to just talk briefly, although it is mentioned in our resistance, about the reference to Mr. Van Patten's phone and how Melody Hoffman's phone did not connect to his hotspot at this time when she was arguably killed at the pond. And, Your Honor, we would just point out that the defense's interpretation of this evidence presumes that Mr. Van Patten, first of all, he took his phone with him, which is not a necessary requirement in order to show his involvement in this case when he went to the area where Melody's body was found. Also, we note that similar data that was on Mr. Ledesma's phone could not be extracted from Mr. Van Patten's phone, so the absence of that is something that is to be expected in this case. The defense argument also makes presumptions that Melody's phone was presumably with Mr. Ledesma at the time that he went down to where Melody's body was found, so that perhaps he went in the car. I don't want to reiterate everything that's in our resistance, but the defense's argument relies on several presumptions that are not required to prove Mr. Van Patten's participation in this case. And ultimately, whether Melody Hoffman's phone connected to Mr. Van Patten's hotspot is inconsequential in light of the impressive amount of evidence pointing to his guilt. Which, not to exclude anything, but just to point out a few of the areas of evidence that were particularly outstanding in this case. The defendant, Mr. Ledesma, the evidence shows were present and together at all stages during the events of February 17th and 18th, 2024. The defendant took photos of himself prior to the incident in this case, with what was later found to be a BB gun, but looked menacingly like a real firearm. He had his Melody Hoffman's password saved in his phone at almost precisely the At the same time, or within minutes of when Melody Hoffman's health data revealed that she experienced a sudden health event. His DNA was found on the duct tape roll that was used to bound and restrain Melody Hoffman, and inside the gloves that the evidence supports were used to handle her body and other items. His DNA was arguably, or the evidence would show, also found on the knife and paracord used to mutilate and kill Melody Hoffman. He was also captured on video surveillance buying and selling 40 cigars after killing Melody Hoffman, and in possession of Melody Hoffman's glasses, which he displayed openly statistically as a trophy for the kidnapping and killing of Melody Hoffman. Your Honor, overall, the evidence in this case, although absent some sort of direct evidence showing what he precisely did to Melody Hoffman, certainly supports all the theories of him being involved in her kidnapping, either as a primary actor or either and better, as well as being involved with her murder. So we ask that the court find that this is not one of those extraordinary cases that the Iowa Supreme Court said may preponderate heavily against the verdict. This is indeed a case that has evidence that overwhelmingly supports the verdict. So we ask that the court overrule this motion for a new trial and the rest of judgment in its entirety.
Thank you, counsel. The defense wishing to reply.
None further.
All right. So, the defendant seeks a new trial on the basis that the jury's verdict is contrary to the weight of the evidence on each of the 3 counts. The verdict is contrary to the weight of the evidence, where a greater amount of credible evidence supports one side of an issue and cause another. In ruling on a motion for a new trial, the court weighs the evidence and considers the credibility of witnesses. Under the case law, trial courts should not lessen the jury's role as the primary trier of facts and invoke their power to grant a new trial, except in those extraordinary cases where the evidence preponderates heavily against the verdict. The court has carefully considered all of the evidence received at trial and finds that the verdicts are not contrary to the weight of the evidence. And in fact, the credible evidence strongly supports the defendant's guilt beyond a reasonable doubt. In regard to count 1, murder in the first degree, the evidence does not preponderate against the verdict. The evidence included but not limited to evidence that Dakota Van Patten directly participated in planning, including by purchasing machetes for the co-conspirators, that he was present with Louisa McKinley Louisa during the events in question, that his DNA was found on incriminating items that were located in Louisa's vehicle. They celebrated the killing after the fact with his co-conspirator, Louisa, going together to buy cigars, and later by photographing himself dozens of times wearing the victim's glasses, and then he admitted to Tyler Meyer that he had Louisa to kill Melody. The jury was properly instructed, as shown in the record, and there is more than adequate evidence to support the verdict that the defendant, the person he aided and abetted, strangled Melody Hoffman, that he or the person he aided and abetted did so with loss of forethought, that he or the person he aided and abetted acted willfully, deliberately, premeditatedly, and with a specific intent to kill Melody Hoffman. The verdict is also supported alternatively with proof that Dakota Van Patten, the person he aided and abetted, killed Melody while participating in a forcible felony, first-degree kidnapping. In regard to count 2, kidnapping in the first degree, the evidence similarly shows that the defendant, or the person he aided and abetted, both confined Melody Hoffman and removed her from one place to another with the specific intent to seriously injure her or secretly confine her. The evidence establishes that the defendant was part of the planning. He was with McKinley Louisa during the events in question, and that he celebrated with Mr. Louisa after. There is no evidence to suggest the defendant was anything but a willing participant. The evidence is further clear that Melody Hoffman suffered a serious injury, was intentionally subjected to torture, and in fact, photographic evidence was located showing the victim bound and bloody prior to her being killed. In regard to count 3, conspiracy to commit a forcible felony, the evidence shows that the defendant agreed with one or more of his co-conspirators to commit kidnapping or murder with the intent to promote or facilitate kidnapping or murder and committed overt acts, including evidence that the defendant purchased machetes in advance of the kidnapping and murder and by his presence and participation in the later events. Therefore, the defendant's motion and arrest of judgment and motion for new trial is Is there any reason why we cannot proceed with sentencing today now that I've ruled on those motions from the state?
No, yeah.
From the defense?
No, yeah.
The state like to be heard on sentencing.
Yes, Your Honor, as the court is well aware, counts 1 or first degree counts, and count 2, kidnapping and first degree carry with mandatory life sentence without possibility. The court has had the opportunity now to sit through 2 trials that have demonstrated 2 juries who have both found Mr. Van Patten and Mr. Gruesome guilty of these crimes beyond reasonable doubt. In the state of Iowa, we have a maximum penalty of life in prison without parole for the most egregious, most horrific, and the crimes that endanger the public the most. Those are the crimes of Mr. Van Patten and Mr. Gruesome committed in this case. The only thing that I think I'd be remiss not to mention in this case is that if there's ever any argument that a life sentence without parole shouldn't apply to somebody because they acted in the heat of the moment and they made a mistake or they didn't, and they had some kind of remorse, it doesn't apply to Mr. Van Patten. Mr. Van Patten celebrated. He didn't have any reason at all to engage in these acts, and every second of this he could have backed out and he wouldn't be here right now where he is. So his actions are deserving of these maximum sentences. And just to make sure the message is sent that if he had been involved in a kidnapping that didn't result in a murder, and these facts were present, he'd have life sentence in prison. So for that reason, we think there's no reason not to impose these sentences consecutively. Both crime by themselves would have resulted in a life sentence. So we think they should both be imposed as consecutive life sentences. With a 10-year sentence imposed to only current. Thank you.
Thank you. Does the defense like to be heard on sentencing?
Thank you, Your Honor. On behalf of the defendant, we obviously are aware of the current state of the law and would ask this court to impose the statutorily required sentences. Mr. Van Patten will request that the sentences run concurrent to one another. This is one continuous act that exists before the court today. Even though there are 3 separate charges, the evidence that we heard over the course of this trial does support the finding that this is a result of a one continuous act. They're not separate or distinct events that would warrant consecutive sentences. So it asks this court to impose them concurrent. Thank you.
Mr. Van Patten, now's the time in the hearing when you can address the court, say whatever you'd like to say, but by the same token, you're not required to say anything. Is there anything that you would like to say today? You're indicating no, is that correct?
No, Your Honor.
Are there victim impact statements?
Yes, Your Honor. There will be 2 victim impact statements by Melody Hoffman's parents. The first one will be by TJ.
All right, you can take the first one. Once you're comfortable there, can you just start by stating and spelling your names and kind of your record and then we can understand?
My name is TJ Hoffman, TJ Hoffman. I am Melody's father. I was asked to give a victim impact statement and an opportunity for me to share how this crime has affected me. But the one responsible could not empathize, let alone understand the full weight of the words I'm sharing. But in an effort to find a catharsis, having Megan come back into my life after being apart for years was a blessing, though it brought its own challenges. Seeing my nieces, nephews, great nieces, great nephews, my mother, brother, and sisters carry this pain. It's too much to put into words. I'm not sure words even have the power to describe it. Anyone who has a child knows that they hold the ability to erase the darkness of the day with nothing more than a smile. And Melody was good at that. Her very first sentence to me was, Why are you so crabby, Daddy? Her mother and me were arguing about money. Melody was very young in speech therapy, if I remember correctly. But her voice had a way to cut straight through my worry. I remember trying to explain to her that I wasn't crabby, I was just concerned about some things, and in that moment, my worry faded. I knew I had to lighten the mood a little bit. When an individual commits an act so cruel and devoid of empathy that it extinguishes not only the life but the future of generations, society has a moral duty to remove that individual permanently from it. Justice in such cases has to be done. Human beings are defined by empathy, compassion, and the capacity to value life. These qualities distinguish us from the cruelty of nature and the chaos of violence. When someone deliberately chooses to destroy innocent life, especially one that is nurturing new life, they reject the essence of humanity itself. To act without empathy is to abandon what makes one human. Therefore, such an individual cannot be regarded as part of the same moral order. The phrase, "it had to be done," is often used to justify actions that cannot be morally defended. It attempts to transform cruelty into obligation, erasing personal responsibility under the guise of inevitability. But there is always a choice. The claim that murder had to be done is not a statement of truth. It is an admission of moral vacancy. To act with intention and to deny responsibility is the hallmark of cowardice, not necessity. When a life is taken, it is not just a single thread that is cut. It is an entire tapestry torn apart. The death of a pregnant woman does not only end her story, but also the lineage of generations that came before it and yet to come. In this case, 5 bloodlines, centuries of ancestors who endured famine, plague, war, genocide, all found their journey ended in a single moment of senseless violence. Such a loss transcends personal grief. It is a wound to human continuity itself. Because the act was deliberate and remorseless, society must respond with equal clarity. Justice is not revenge, it is preservation. To allow someone who rejects the core principles of humanity to walk freely among others would be to endanger the very concept of morality itself. Therefore, the imprisonment is not only justified but necessary. In this sense, the phrase, "it has to be done," finds its true and rightful meaning. The protection of life through the removal of one who destroys it. You don't deserve the word human. Humans feel empathy. Humans know compassion. Humans value life. You have none of that. You are not human. You're a monster. But even monsters have names. Your name has already been forgotten. Thank you, Your Honor.
Now hear the second.
Yes, Your Honor, this is that statement will be my
You would start by stating and spelling your name.
Melody Hoffman, MEGAN, HOFFMA. I know Melody would want me to forgive you, but I'm not sure that'll ever happen.
each and every one of us. She will be remembered for the kind, caring, loving, organized, silly, artistic, music-loving, slime-making, selfie-taking, video-making, supper-cooking, animal-loving girl we all remember. I don't believe for 1 minute that McKinley made you do it, or that you made him do it. I believe that you're both 100% guilty of murdering Melody, our daughter, and their loved one. You're both cowards. Neither one of you had the balls to stand up to each other and do the right thing. I also know that you two are the most naive, stupidest criminals that ever walked this planet. Leaving all of her belongings in the trunk of the car, linking your phone to hers, having her password, her deceased sister's birthday, in your phone, and being seen together on surveillance videos before and after the crime. Let's talk about your selfies for a minute. What are you, in middle school? At the beginning of the night of February 17th, your selfies didn't include any classes. And then, all of a sudden, you had classes. You took more than 200 selfies. 200. With them on. Did you see them as a trophy or a souvenir? I don't. I see them as the evidence that put you away for the rest of your life. By the way, thanks for taking them home with you. You made the job a little easier for everyone seeking justice for Melody. Maybe now you can get your own state-issued, non-working classes. I've been called a helicopter mom a few times now, and I take that as a compliment. Being a loving, caring, concerned, supportive, devoted mother to Melody is an honor. I am proud to say this helicopter mom got my daughter's murderers put behind bars in days, instead of weeks, months, or years. You fucked with the wrong mama. You messed with the wrong family. I'm sorry you never felt love. Anybody capable of doing the things you did could never fit into a loving, caring, supportive family. I'm sorry you never experienced a family with such strong characteristics. In fact, I don't see any of your relatives here supporting you today. Maybe the issue's you and not the rest of us. I'm relieved to know that there will never be another innocent victim with your name attached to them. If you would have let Melody get to know you, she would have given you the shirt off of her back. Instead, you took it, and so much more. I want you to think about her during every disgusting cold meal you eat. Every time you lie down on that cold, hard bed. Every time you wake up to the concrete walls and iron bars. Every birthday, holiday that you don't get to celebrate. Every time you have to ask to use the restroom. Every time you step out of line. Every time you have a nightmare. Melody is providing for you. She will forever provide those bars that obstruct your view for the rest of your life. And I hope she haunts you forever. Justice will be served to those who deserve it, to its fullest extent here on earth. A much higher power will get the final justice. I have no doubt when your time comes, you will not be allowed in the same place we all know Melody is now, with her sister Ellie, safe and far away from everything evil like you and McKinley. I I'm not the only one determined to do this. So, from all of our loved ones, we all wish you the life that you deserve until you take your last breath.
It makes a little difference since the sentence is mandatory, but the state did make mention of me hearing the evidence in both this case and the McKinley-Louisa case, and I just want to state for the record that my sentences that are going to be issued here today are based only on the evidence received in this case and have nothing to do with the evidence heard in the other case. The sentence in this case for murder first and murder and kidnapping first is a mandatory sentence of life in prison, which is the sentence the court will be imposing. While the sentence is mandatory, it's also the sentence that is appropriate for these violent, incredibly cruel, and completely senseless acts. Your offense cuts the young life short and deprived Melody Hoffman's family and friends from having her in their lives, which is understandably devastating to them, but also undercuts the safety and feelings of security in the community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes and is necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit a forcible felony is a 10-year indeterminate prison term. While it is largely symbolic in this case, given the sentence of life in prison for the other offenses, the court does find that the maximum sentence of 10 years in prison is the appropriate sentence based on the level of planning involved and the fact that the forcible felony involved a Class A felony. So at this time, the court adjudicates the defendant to be guilty of the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21b. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates the defendant to be guilty of the offense of kidnapping in the first degree in violation of Iowa Code Sections 710.1 and 710.2. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor later commutes the sentence to a term of years. The court further adjudicates the defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1 sub B and 706.3 sub 1. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for an indeterminate term not to exceed 10 years in order to be fined in the amount of $1,370. The defendant is given credit for all qualifying time previously served on this offense. The term of incarceration as to this offense only may be reduced because of good time for credits and program credits, and the defendant may be eligible for parole before the sentence is discharged. While largely symbolic, Count 1 and Count 2 will run consecutive to each other. The reason for the consecutive sentences is that the kidnapping included separate planning and represented an entirely separate cruelty to Melody Hoffman, as she was picked up with no idea of what was coming, with all panic and separate torture associated with being taken, confined, and moved, all of which occurred before the separate act of murdering her. The court finds that because of that, and based on all the facts and circumstances of the two offenses, that they should run consecutive to each other. The sentence in Count 3 will run concurrent to Counts 1 and 2. Temporary custody is placed with the sheriff and then transferred to the DOC. Pursuant to Iowa Code Section 910.3b, defendant shall pay restitution in the amount of $150,000 to Melody Hoffman's heirs of law. Now, certain defendants are presumed under the law to have the ability to pay what we call Category B restitution, but defendants have the right to request a determination of the reasonable ability to pay. Mr. Petrova, is your client intending to file an application for determination of Category B restitution?
Yes, Your Honor, we did file one with this case.
I've not had a chance to review that. As the state has any objection to the court reviewing that application and making the determination, basically we can file it. All right. And so, sir, what that means is that I'll either grant that request and find that you do not have the ability to pay, which is what I expect will occur. For any reason I would determine that you did have the ability to pay, I would reset this for hearing so that you have a chance to be heard on that. Defendant shall submit a physical specimen for DNA profiling pursuant to section 81.2, 901.15, sub A. Defendant's prior bail provisions are exonerated, no appeal bond is set. In determining the sentence, I consider defendant's age and circumstances, the nature and circumstances of each offense, and the fact that the sentences for murder first and kidnapping first are mandatory under Iowa law. Finding the sentences will offer the defendant the maximum opportunity for rehabilitation and provide for the protection of the community. Now, Mr. Van Patten, you have the right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of an appeal, you have the right to apply to the court for appointment of counsel and for furnishing a transcript of the proceedings. All is provided in Iowa Code Chapter 814. In order to perfect an appeal, you must file a notice of appeal with the court here in Manhattan within 30 days of today's date. This is a jurisdictional requirement, which means that if you do not file a notice of appeal within 30 days, you will be forever denied the right to appeal. Likewise, failure to comply with the other provisions of Iowa Code Chapter 814 could preclude you from pursuing your appeal. If you do appeal, you must cause to be served on and delivered to the Iowa Attorney General a copy of the notice of appeal. Is there anything that the state believes I missed there?
Okay.
The defense?
No, Your Honor.
All right, order.